afternoon, everyone, or good morning to others. Thanks for joining our webinar today that's being run by the Young Professionals Committee of the Energy and Resources Law Association. The topic of the webinar is Shareholder Activism at Energy and Resource Companies. I'll begin by acknowledging the traditional custodians of the land on which we work and live, and recognise their continuing connection to land, water, sky and community. We pay our respects to elders past, present and emerging. My name is Shalini and I'm the Secretary of the YPC. I'll just be giving a quick introduction to the session before we hand it over to our speakers. So both of our speakers are from the Australasian Centre for Corporate Responsibility, also known as the ACCR. The ACCR is a research and shareholder advocacy organisation that's headquartered in Australia. It holds a small portfolio of shares for the purpose of corporate engagement and uses its expertise in shareholder strategy to assist institutional investors to understand investment risks and opportunities during the energy transition. The ACCR is philanthropically funded, not-for-profit, and independent. So it's my pleasure to first introduce James Fitzgerald. James is the ACCR's legal counsel and First Nations engagement lead. He's an experienced lawyer, negotiator and strategist, and has been closely involved in the development of native title law and land use policy, working with Indigenous peoples, governments and industry peak bodies at both the state and Commonwealth level. James is currently a director of the Diplomacy Training Program Limited, and he's also an adjunct associate professor at the Law School of the University of New South Wales. Our second speaker is Alia Hutchison. Alia is the Supporter Engagement Officer responsible for maintaining close ties to ACCR's shareholder community and supporting the filing of shareholder resolutions. Alia is an Indigenous woman with connections to Wangutha, Naju and Mirning language groups across Western Australia. She holds a Bachelor of Arts in Australian Indigenous Studies. Alia joined the ACCR from a role at Rio Tinto in which she provided advocacy and support to Indigenous employees, facilitated the implementation of native title agreements in collaboration with traditional owners, and supported the design, implementation and execution of Indigenous ranger programs. So now that I've introduced our speakers, I'll just give a reminder to the audience that there will be a Q&A at the end of the presentation. So you're welcome to post any questions that you have into the chat. There's a chat function in this meeting, or if not, you can raise them at the end of the presentation. So now that that's all out of the way, it's my pleasure to hand it over to James and Alia.
Thanks, Shalini, and thanks for that great introduction. I can skip over that bit now that you've introduced us, so I won't have to do it myself. Lovely. What we'll cover off on today, James is going to talk a bit about ACCR's history and our approach to shareholder advocacy, how our work interacts with corporations law, some recent examples of our work with some listed companies, and then he'll throw over to me and I'll have a quick chat about how retail shareholders, so just day-to-day people, can get involved in our work. So I'll throw over to James. Thanks.
Oh, thank you, Alia. And Alia didn't mention it, but she's much better prepared than me and has some nice slides to show you, which I don't, so bear with me. Thank you, Shalini. Thank you for that kind introduction, and to the association for having us today. We appreciate it. I'm coming to you from the land of the voiceless Fitzgerald people in eastern Sydney. What I thought I'd do is just try and explain a bit about who we are, what we do, and how we do it. Shalini's already gone part of the way there. But technically, we are approved, a not-for-profit approved research institute. Under our constitution, our purpose is, the purpose of ACCR is to promote, quote, promote ethical investment and assist ethical investors so that humanity may live more justly and within the carrying capacity of supporting ecosystems. It will do this through education, research, collaboration, engagement, and advocacy. ACCR just turned 11 this week, I understand. Relatively new organisation in Australia. I am no expert in this yet, but our founder, Howard Pender, tells us that the genesis of these kinds of organisations is mainly in the UK and the United States, and principally among faith-based organisations historically. We are not a faith-based organisation. So that's who we are, what we do. Until recently, ACCR's main focus has been on improving the environmental, social and governance performance of the top 50 to 100 ASX listed companies, consistently with the purpose I just read. That's in the past included engagement on issues as broad as climate and emissions, industrial relations performance, social impacts of mining. We were heavily involved in the scandal that arose in 2020, for example, when Rio Tinto blew up the Juukan Gorge caves. But more recently, ACCR has sharpened its focus towards company performance on the transition to a renewable energy-based economy. ACCR is currently active as a shareholder in heavy carbon emitting ASX listed companies, and increasingly also in overseas heavy emitters around their commitments to Paris-aligned targets, for example, and their performance in pursuit of their commitments. As the purpose that I read out suggests, our principal ways of engaging are through research and publication of reports. And we have a growing and highly impressive group of scientists and technical people in the organisation now. It's grown, I think, when I began in 2018, there were 5 of us. There's now over 35, and many of those people have PhDs or come from major oil and gas companies themselves. So research and publication of reports, ongoing dialogue with institutional investors and company executives. Where necessary, we will exercise shareholders' rights under the Corporations Act. I'll expand on that in a little while. And occasionally we've also engaged in litigation in pursuit of that purpose that I mentioned. So a little bit about, since our focus is now primarily on climate work, and that necessarily involves heavy emitting companies, I'll talk a bit more about that. About where we start from, guided by the advice of the International Energy Agency and other global peak scientific bodies. ACCR advocates for Paris-aligned company policies, goals and plans, and tries to keep companies to their word in the realisation of those goals and plans. As you all know, Australia is a signatory to the Paris Agreement and its collective goal of keeping global average temperature increase well below 1.5 degrees compared with pre-industrial times. The International Energy Agency has advised that if we continue to develop new coal, oil and gas projects, we won't achieve that goal. And so hence the urgency of the energy transition. We view the transition from a fossil fuel-based economy to renewables as one of the greatest challenges and also opportunities faced by humankind since the Industrial Revolution of the 18th and 19th centuries. I find that a helpful way to look at ACCR's advocacy work on climate and just transition as being by looking at time horizons. In our view, prompt and effective action away from reliance on carbon-based fuels and towards renewable energy is, generally speaking, in companies and shareholders' best long-term interests. However, short-term thinking, resistance to change and institutional or policy blocks still make the challenge large. There's both morality and self-interest at play. The challenges are different in different sectors. Where companies show initiative and ambition in their transition plans, we try to do what we can to help. For example, we're currently helping Rio Tinto in relation to the company's publication of a series of papers outlining the challenges of decarbonisation in different parts of its business and the regulatory policy settings necessary to meet those challenges. On the other hand, where companies have a diminishing future in a decarbonised economy, such as pure play coal, oil and gas companies, our role is to provide good quality information to help shareholders understand where their long-term interests lie. That's the what we do. Now, as to the how, we try to approach all of our engagements in a collegial way. Typically, we start with high-quality research, as I mentioned, where our research identifies ways in which a company may improve its performance. We'll share that research with interested institutional investors and also with the companies concerned. Where the company in question is open to discussion, we'll engage with the company and, if possible, with other institutional shareholders about ways in which the company can improve its performance. In many cases, an accommodation is reached at this point. An example is, say, the Say on Climate initiative of the past couple of years, where we proposed to companies that they present their climate action plans to shareholders for a vote at the company AGM. A number of companies were happy to do so. Where agreement isn't reached, we may decide to escalate to the exercise of shareholders' rights under the Corporations Act. Generally speaking, the best and most durable outcomes arise from agreement, where companies see the value of a proposal, take ownership of it, and take the necessary steps to give effect to it. In this context, the formal rights of shareholders are relatively weak in Australia, and I'll go into that in a moment. But they can still be used to draw attention to issues of importance to investors and to put issues on the agenda for further development between shareholders and companies concerned. Just one aside on that, there is a cultural aspect to our working environment. And that is that, as will become apparent in the discussion of the Federal Court decision in ACCR and Commonwealth Bank, there is not historically a culture of shareholders being active and vocal and engaged in the way in the companies in which they invest in operate. I'm told, I'm again not the expert, but I understand that the situation is rather different in other jurisdictions, particularly the United States and the UK. Part of what we are doing is, in effect, bringing the culture of the relationship between shareholders and publicly listed companies closer to the sort of relationships that you might find in the United States or the UK. So getting back to our modus operandi, where we do proceed to the rights phase, to date we've mainly relied on just two sections of the Corporations Act, Section 249N and Section 249P. Section 249N concerns members' resolutions. Shareholders under Section 249N, shareholders can give a company notice of a resolution that they propose to move at a general meeting if they meet certain requirements, the most significant being that the request is made by either at least 100 shareholders eligible to vote, or alternatively shareholders representing at least 5% of the capital of the company. Section 249P concerns members' statements. Shareholders can request that the company distribute to all members with its notice of annual general meeting or another general meeting a member's statement about a resolution that's proposed to be moved at a general meeting or any other matter that may be properly considered at a general meeting. Similar threshold requirement that the request must be made by 100 shareholders or 5% of the capital of the company. There are other provisions, other requirements, but essentially the benefit of this is that if the criteria are met, then it's the company that meets the cost and the effort of distributing those statements to all shareholders in advance of a general meeting. An example of where you might use a statement like that is in relation to a proposed resolution by a company concerning the reappointment of directors. A little bit later, Alia will talk about how we go about meeting those thresholds. That's her primary role at ACCR. As I mentioned before, these formal rights that we have used to date are, in a legal sense, relatively limited. ACCR was involved in one of the court cases that confirmed those limitations. That's ACCR and the Commonwealth Bank of Australia, and I'd like to tell you a little bit more about that. In October 2014, ACCR commenced proceedings in the Federal Court seeking declarations that ACCR's then proposed members' resolutions relating to greenhouse gas emissions could be validly moved at Commonwealth Bank's AGM pursuant to Section 249N. The resolutions, and this is a good insight, a good example of the kind of resolutions we'd be putting up. This is certainly typical of others. The resolutions included asking the company to create and release a report detailing their greenhouse gas emissions and plans to mitigate the emissions, and asking the company to publish a detailed report on the risks posed by climate change to the bank, as well as mitigation strategies that the bank would adopt. In July 2015, the court rejected ACCR's resolutions. The court found that shareholders do not have the authority to propose resolutions that relate to the management of a company unless the company's constitution permits such resolutions. The judge held that the shareholders do not have the power vested in them by the company's constitution or the Act to move even advisory resolutions concerning the way in which directors should exercise their management powers. ACCR appealed to the full federal court, and in June 2016, the full court rejected the appeal and affirmed the previous judgment that advisory resolutions which are not grounded in powers granted by statute or by the company's constitution are legally ineffective and don't have to be put to shareholders at a general meeting. The court found that shareholders do not have the authority to propose resolutions that encroach on the management of a company. After the full federal court's decision, ACCR developed a workaround that involved proposing 2 resolutions at company AGMs. And this is how we've been operating since I arrived in 2018. First, we'll put on a resolution to amend the company's constitution to permit member resolutions on management issues. And secondly, a resolution on the substance of the issue being pursued at the time. Our experience is that typically these first resolutions receive little, if any, support. However, we've seen second substantive resolutions receiving support up to and above 50% of members voting. The upshot of all this is that members' resolutions proposed by ACCR have little formal legal weight. In fact, they're more in the nature of a straw poll of members' sentiment. However, that sentiment alone, if strongly enough expressed, can be persuasive to company management and, on occasion, can lead the company to change course of action. More recently, ACCR has become concerned about the lack of adequate regulation of fossil fuel companies' representations to market. And so we've again entered the federal court, this time in 2021, when we commenced proceedings against Santos Limited, alleging breaches of the Corporations Act and the Australian Consumer Law by engaging in misleading and deceptive conduct relating to Santos's clean energy claims and its net zero plan. The key allegations are that Santos's representations that the natural gas it produces is clean energy was misleading or deceptive, and that the extraction and use of natural gas as an energy source is a material contributor to climate change and global warming. The second is that Santos's representations about blue hydrogen, that blue hydrogen is hydrogen produced by natural gas with carbon capture and storage, is, quote, clean or, quote, zero emissions. We allege that was misleading or deceptive. Thirdly, that Santos's net zero roadmap, that is its so-called, its 2020 report roadmap of reducing emissions by 30% by 2030 and being net zero by 2040, which it described itself as clear and credible. We say that was misleading or deceptive because, among other things, Santos failed to disclose that its net zero plan didn't account for expected production and or emissions growth from oil and gas exploration opportunities beyond 2025. That's not a full description of the claims, but it gives you a good sense of where we are. The party's lawyers have been in a conferral process for most of 2023 under the supervision of Justice Lee in the Federal Court. It seems unlikely the matter will be heard before at least 2024, mid-2024, I would hope. The next directions hearing is on the 18th of December, if anyone's interested to tune in. But as the matter's ongoing, obviously it's not appropriate for me to talk too much further about that. It is worth noting, though, that since ACCR commenced the proceedings, ASIC appears to have become more active in the climate space at the moment, mainly with investment companies' claims about ethical investment. Now, that's really all that I had to sort of offer you. I'm very happy to ask questions a bit later on, but perhaps we should move now to Alia.
Thanks, James. Okay, so my section really looks at how you can participate in our work if you're interested. So I'll share some slides very quickly. Bear with me. Okay, so James sort of covered off on the corporations law already, but essentially there's two mechanisms that we use when engaging with companies through the AGM. One is members' statements. So they're both formal ways that we can share our concerns for consideration at the AGM. So members' statements, they don't go to a vote at the AGM, whereas the shareholder resolutions, they're lodged for consideration by all shareholders, as James already explained how that's done. In order to do this, we require 100 shareholders. So our retail shareholders really make this work possible. We do engage with institutional investors as well, but it's really our retail shareholders that sign up with us that enable us to be able to file our resolutions and bring them to the companies at the AGM. And as Jane mentioned earlier, they don't necessarily need to be passed to be successful. Some of our resolutions have been withdrawn because the companies have come on board to work with us. Other times, it's just getting our concerns in front of the audience, regardless of what the vote ends up landing on. So just a bit of an overview, getting started as an investor. Some of you are probably well across this already, but I'll just skim through these points. And it's also important to note that ACCR obviously isn't, we don't give financial advice. You've got to do your own research and make those decisions that you're comfortable with. So research the companies that you want to invest in. Your shares must be held directly, so they must be individual shareholdings, a self-managed super fund or trust funds. They can't be shares held in ETFs, mutual funds, or shares held in your general superannuation. You'll need a CHESS-sponsored broker or a financial advice. You can use, a financial advisor if you like. We have a few different ones that we work with. The ASX has a minimum marketable parcel of $500. So the first time you buy any shares in a new company, you must buy a minimum of 500. From there on in, any subsequent purchases or shares you buy can be a lesser amount. Generally, one share is one vote at the AGM, and ACCR doesn't require you to share your size of your holdings with us. That's irrelevant for our filing of the resolutions. We just need the names of the companies that you hold. So if you've got some shares and you're interested in participating with us, you can sign up via our Shareholder Hub. All we require from you is the last 3 digits of your HIN and your holdings, and your address and entity name. It's vital that these are correct. A big part of my role is what we call registry inspections. So I've got to check that all of the details that we have on file match exactly what's on the company shareholder register. If there's any discrepancies, the companies can come back to us and deem a shareholder invalid and strike them off our list and try and bring that number down under 100. So on our Shareholder Hub, you just log in, add your shares, add all your details, and then sign our agency agreement, which essentially gives us the authority to include you in any shareholder resolutions or member statements that we file. We don't have access to your shares or act as your proxy for voting. I have had people contact us, often asking if we'd like their proxies, but we encourage shareholders to vote as they see fit. In cases where we formed a strong opinion on voting, we'll share this with shareholders with a bit of guidance for that. Shareholders will always have the opportunity to opt out of any resolution. So if there's any conflicts of interest or some reason why someone may not want to participate, that option's always available. And if you buy or sell any shares, keep these updated on our hub. And that's it in a nutshell, really. If you're interested in having a look at our work some more, you can visit our Shareholder Hub, the link here. We can share that with you post-event. And our ACCR general website has got a lot of information on there with our engagement with companies at the moment. We've got a data set of all of the resolutions that we filed previously, including where they landed on the votes, and plenty more information on there if you're interested. Well, that was a very quick overview of how to participate with us. So we might throw the floor open to questions. There are a couple in the chat. I'll throw those over to James. And if anyone else has any questions, feel free to put them in the chat or pop your hand up and you can ask them directly. Thanks. Over to you, James.
Thanks, Alia. Look, your mention at the end of the website is really important. I've had a look at it recently for the first time in a couple of months, and I was really surprised at how it's come along. There's some really fantastic resources on there, some high quality research. We are not for profit, just there for free. Very much worth a look across a range of different issues. And as Alia said, also because of the sense it will give you of how we've operated for this past 3 or 4 years, particularly. Now, going to the questions. Here's John Sutherland. Thank you, John. You're very kind. This first question, the focus of shareholder activism is focusing on progressive aims, climate change, social impacts, renewable transition. Are you aware or do you see any potential development of shareholder activism pushing the other way? Recent example is some criticism of corporate spending supporting the voice. This is it's a great question. It's a very broad one, and it brings in the wide biosphere of the investor world. It's my introduction to it was 5 years ago, and I'm still learning a lot. But in any given top 100 ASX company, you're going to find individuals, small shareholders, self-managed, retirees, all the way up to the BlackRocks and the Vanguards, the really big institutional investors, and the superannuation associations in between. There really is a range of views there, and so yes, absolutely. In answer to the question, it's certain that there is pressure coming from different directions on different issues. A big part of what we do is look at where there's consensus on issues that we feel are important to pursue. And that might be a very different group of institutional shareholders for different purposes. But I suppose, I think most of us here are lawyers. We know that members are part of the company. It's also important to understand that the investors are looking for a return on the investment. So our advocacy really must, and our research really must be focused and remain focused on the interests of shareholders. And that's really what I mean by this, this intersection of morality and self-interest. You'll probably be aware of this growing theory of the universal investor. Some of the investment companies now, some of the funds are so large that they have investment in just about every part of the economy, and therefore this brings in new questions about, well, if you're investing in new oil and gas projects, what's that going to do to your investments in, for example, in agriculture, where we know with increasing certainty what the impacts of producing more oil and gas are going to be. So it's incredibly complex. Fortunately, we've got people coming to the organisation with extraordinary knowledge and skill in that area. I'm going to duck the Casamatis decision because I'm embarrassed to say that I haven't been following it. What I can say is that I think we all know that companies are facing a range of different sort of approaches to questions of speeding up the transition to a renewable economy. In the last 24 hours or last 48 hours, I think we've seen a settlement between the government and the Commonwealth government and plaintiffs in relation to the Future Fund and disclosures about where those investments are going. We've got ASIC now becoming increasingly active. An interesting choice of targets. They've gone for investment companies that make claims about being ethical when, in ASIC's view, they are not. We've got Sharma, where the federal court, Justice Bromberg, dabbled with the concept of a duty of care on decision makers when it comes to new oil and gas, new fossil fuel projects. This is only going to increase, and it's been an extraordinary thing to watch over just this past 5 years, given where we were then and where we are now. I'm still looking at these, and then there's on the how. What rights and procedures you use? Do you see much relevance or use for the OECD guidelines? Again, it's a great question. It's a challenging question to answer. The OECD guidelines have a very important role to play, particularly for communities affected by the actions of large mining companies, especially, but not exclusively, large companies impacted by their acts. But we see a strange, one of the experiences from the 2020 destruction of Juukan Gorge and our engagement with investors then, not that the OECD guidelines were involved, but by extension. As mentioned on first principles, investors are interested in return on investment. One does get a sense that as long as they don't know things are going wrong, or they don't inquire too closely as to how the sausages are made, they're very happy to continue to take the return on the investment. So just engaging with investors to explain how mining works in Australia, for example, was extremely powerful, because they could no longer say, well, we've read Rio's annual report and they say everything's fine. The reality collided with the beautiful words in the company's reporting. I see the OECD guidelines in that sort of context, where issues are brought. And by the way, for those unfamiliar with the OECD guidelines, I think John actually has a very important role in their administration in Australia. They're described as soft law, with a view to becoming harder. And that is to say that, there are principles set out, there's a complaints mechanism, but there aren't a lot of consequences in strict legal terms for companies that are found to have breached the guidelines, at least in Australia. It might be a different situation in Holland, in the Netherlands or Canada. But the value I see in the guidelines is that, similarly to the way we use some fairly flimsy legal provisions for greater effect, they're important in bringing things out of obscurity and before decision makers, before investment decision makers, and before companies. A lot of ASX listed companies spend a lot of money on public relations, investor relations, on keeping the message clean and sweet. And a big part of our work is just inquiring past those reports to what might actually really be happening. I hope that's an adequate answer, John. Gee, by golly, I feel like I'm in a one-way conversation with you, John. Is the recent ASIC ethical attention just greenwashing, or is it covering more widely? I need to be a little bit careful. We've been in discussion with some of the people at ASIC. I'm just trying to cleave in my mind. So I suppose anything they've told us, they'd be prepared to tell public. I may be wrong, but I think this past 12 to 18 months of foray into the pursuit of investment companies in relation to their greenwashing claims is pretty much ASIC's first go at this new area, or at least a new area for them. I don't know how widely they propose to go. To be honest, there are days when I wonder why it is left to small not-for-profit research organisations like ACCR to be challenging company claims in the federal court. There are regulators, I believe, that should be doing that. But one step at a time. I mean, ASIC's role obviously goes much further than greenwashing to other areas, but in relation to climate matters, to my knowledge, that is the only sort of category that they're currently working in. One thing to keep an eye on is, and some of you may be familiar with the fact that the Department of Treasury has released a couple of papers concerning a proposal for climate-related reporting by companies that meet certain thresholds in Australia. It's a very welcome, in global terms, it's a highly welcome development. Though one aspect of it is, essentially they're saying it's still in a very broad development phase. They talk about, the development of quote industry accepted standards by which this reporting will occur, industry accepted benchmarks, etc. There's a lot of room for wriggling in there. But on the transition to this new arrangement, one of the somewhat surprising proposals, and I suspect this probably arises from submissions made by the Australian Institute of Company Directors. I think their submission to these papers was that there should be a holiday on liability for directors on the reporting requirements, the new reporting requirements, because it's also new and complex. Certainly for some small companies that may be the case, but a lot of large companies have been reporting on climate for years. So it's a little bit disappointing, I have to say, to see the AICD coming in with a proposal on making that sort of contribution on an issue of such great importance. But one feature of the the current Treasury proposals arising from that submission, I suspect, from AICD, is that there should be a 3-year transition period where actions like the one that ACCR has taken against Santos will not be permissible, and that only ASIC will have regulatory authority and function for the 3-year transition period. That does beg the question, you know, given ASIC's performance to date and its composition, is ASIC equipped for that function if it is given to it? I certainly hope so. I can say that from being involved in some so-called greenwashing litigation, it's scientifically heavy, and I don't know how prepared any of the regulators are to engage in an effective way at this stage on these kind of issues. Sorry, there's a long-winded answer. And thank you, John, for your many queries.
Yes, thank you, John. There's no more questions in the chat, but I'll just give a moment if anyone wants to raise any additional questions. No. Not sure how long to wait for people to jump in. But if not, thank you so much to James and Alia for first of all taking time to prepare for this presentation and then being here today to deliver it. So thank you very much. And finally, before we conclude, I guess I'd just like to thank everyone who's attended. We hope you join the YPC for our next webinar. Thank you, everyone. Have a good afternoon.
Thanks, Shalene and everyone.
Thanks, Shalene.